Next, I'll call two consolidated cases under case number 21. The first is docket number 370776, William Harrison versus Melanie Hollis. Next is docket number 370791, William Harrison versus Melanie Hollis. As of 9 o'clock this morning, both parties are endorsed for oral argument.
Good afternoon. My name is Stefanie Lambert and I represent the plaintiff appellant, Mr. Harrison, who is present to my left. There are two matters before the court in this appeal that I'd like to address, and I'll begin with the issue of the refund under MCL 168.867 subsection 6. That language, as we've stated and we rely upon in our briefs, does not include the words or terms early voting site or absentee voting board. The judiciary is not the appropriate mechanism to amend a statute, and the court cannot add new words or terms to statutes. And I would rely upon King versus Oakland County Prosecutor 303 Mishap 222, where it states that the holding was the legal terms at the time of ratification and when the are clear and unambiguous, leaving no room for the judiciary to interpret and must apply the terms in the statute. This recount took place in 2023, a full year after the proposal in 22 had passed, leaving an entire year for the Michigan legislature to amend or pass new laws to provide for early voting site to require an additional fee. And I would rely upon similar holdings in County of Wayne versus Heathcock 471 Mish 445, Kane versus Waste Management 472 Mish 236, Hobart versus Detroit 17 Mish 246, and Stice versus Liquor Control 28 Mishap 358. The Michigan election officials correctly stated that elections in Michigan are run at the most lower level of the municipal offices. It's the cities and townships that run and have the constitutional duty and authority to conduct fair and accurate elections in the state of Michigan pursuant to our Constitution and hold the records pursuant to 4165. What the law does not state is that vendors run our elections. In Michigan, 3 vendors can be utilized by clerks, which would be Dominion, Hart, and ES&S, but they are not to run our elections, and nowhere in the Michigan law does it provide for a vendor to run the election. A recount is a check and balance to ensure essentially that the votes were legal votes were properly counted. And legal is the key term. The most important consideration that I don't think any court has considered in Michigan would be attachment E filed in this case, which is the EAC report. And while it has been stated over and over again that any issue with an election is misinformation, this is from the United States Election Assistance Commission. And on page 4, it discloses that the vendor submitted a root cause analysis showing that its source code was erroneous, which resulted in an inaccurate tally of an election. And this is significant because in Michigan, we report and certify our elections based upon electronic results. The only check and balance on a vendor or a machine count would be a hand paper count and an investigation done at the local most level to be a check and balance to make sure that the electronic reporting is accurate. The election process should never be a partisan or political process. And Mr. Harrison wants to make sure every vote in this election counted regardless of political affiliation. It's not a partisan process. He submitted in his brief affidavits reflecting, and this is very concerning because none of the precedent prior to this case contained early voting. Affidavits from people that had voted but were not reflecting as having voted. So what is the explanation for that? Only an investigation would reveal that. And that would mean at the lower level, before an election is certified, a full investigation would have to be conducted looking at paper and all records to make sure that it reconciles pursuant to 4165, and they should be maintained. The court found this issue to be moot. It's not moot because the mootness doctrine states that anything that is likely to reoccur is never moot. And as we know, in the 2024 election that just took place, the Secretary of State did a press release that said that there was a malfunction. Well, she used the slang term glitch with the election machines, and that she had to ask the vendor what the explanation for the malfunction would be. So if we have a scenario where malfunctions can happen with vendors, where nowhere in Michigan law does it say that a vendor runs an election, we have to have a check and balance, which would be a recount and an investigation.
Did a recount happen here?
It's Mr. Harrison's position that it did not, because the machines were used to, again, retabulate, which the EAC report in attachment E details why that's problematic. In that situation in Williamston, Tennessee, the clerk.
So there's an EAC report
Correct.
that you've attached that explains that there was issues with the particular machinery used for the initial vote count and the recount. But the report you have indicates an issue on a single machine or multiple machines in Tennessee.
So in Tennessee, it was a municipality where the clerk did a hand count after the machine count because she suspected something was wrong. She was taking notes throughout the day. She was diligently doing her job. Her hand count did not match the machine count. So she assumed that she counted wrong. So she took the same stack of ballots and put it back through the machine, and the machine count matched the second machine count. So she said, oh, I was wrong, but let me hand count again. So she hand counted again. Her hand count matched her hand count. So her hand counts were all matching, which differed from the machine counts that were all matching. So she involved the Secretary of State, which couldn't answer her questions as to how this could possibly happen. The Secretary of State involved the EAC, which is the federal arm of elections, and the EAC couldn't answer how this could happen. Only the vendor, where there's no transparency, was able to disclose and reported that the root cause analysis was erroneous source code. So that is a problem and would be
Do
unconstitutional.
we have anything to say that the machinery used in this election had an erroneous source code problem?
That's where the investigation needed to take place along with the recount, because yes, that would be attachment G, and the affidavits under attachment C that reflected that many voters were saying that they had voted, yet their vote was not reflected as having counted. So only a full investigation where you reconcile every aspect of the election, because machines are not transparent. When we go to the bank and we pull out cash, the teller runs it through a machine, which tallies it, and then they hand count it in front of you to make sure the hand count matches the machine count. That's the check and balance. So all previous cases that have considered machines for a recount or the statute did not consider what has now been disclosed by the EAC, that there can be erroneous source code. And again, this is not political. We don't know whose vote may or may not have been counted. If you're utilizing that process to conduct a recount, it's essentially just potentially counting errors again, because it's not transparent. That's why it's so important to conduct the investigation on the spot. And that's not moot. That could still be done at this point. Everything has been preserved. And then we would be able to see and actually verify. And the lay definition of recount is to add it up again and investigate what actually happened and how there could possibly be so many affidavits where people are saying that I voted and the system is not reflecting that I actually voted, and I want to know what happened with my vote. I have no idea what their political party is. But no court has been able to consider this EAC disclosure, which took place in March of 22 in conjunction with recounts. And that's what Mr. Harrison is asking of this court. With that, I'd be happy to answer more questions or reserve my time for rebuttal.
I'm just looking at the plain language of MCL 168-867, and it's not clear to me where it affords you the right to guide the recount in the manner that your client sees fit. So I understand the desire for the investigation. I understand that the evidence produced of fraud. I understand the apolitical nature of the request, but what I'm concerned about, just given our status as an appellate reviewing court, is where in the statute a petitioner is afforded the right to so intensely guide the recount process.
That's a great question, Your Honor, and it would be our Constitution, it would be the United States Constitution that every legal vote must count. And that is where it just didn't take place. He asked for an investigation, called for one, and the ballots were simply just put back through the machine. And there was no investigation with regards to the affidavit. So it's not just, so there was the Barrow case, I think the court referred to, which did not consider the EAC report where it had been disclosed there can be erroneous source code that results in inaccurate
So are the
tallies.
individuals who voted claiming that their constitutional rights were violated in this lawsuit?
Yes,
Okay, and so they're plaintiffs in addition to your client.
my client has filed the matter and he's included, and he has standing. And so if there's dilution at all in an election, which it appears there could be here, because there's a number of individuals that have said that they voted and it's not counting. It's not just his one vote that should be considered. It's the fact that there was no investigation conducted. And so while the Barrow case talks about a machine recount, this is a new consideration for this court with regard to the EAC report that we report in Michigan electronically. And the check and balance on that would be a recount. And recounts are expensive. And Mr. Harrison overpaid for a recount and was essentially forced to when he was submitting for one because he wanted it done. There's a short time window to do that. And it's not moot. If it could resolve an issue as to a systemic problem that we could have, where we have a number of individuals that have said they voted and it's not reflected as that they were counted, their vote was counted. If that could resolve any problems in future elections or in this election, it's not moot. And for those reasons, we ask that it be reversed and affirmed on the refund matter. And I would reserve the remaining time.
Okay. You have time for rebuttal.
Yeah.
Okay, just as long as you manage your time.
Yeah, I guess for clarity of the panel, this is a bit procedurally unique in that.
Can you go ahead and put your name on
Oh,
the
yeah, I'm
record?
sorry.
Yeah.
Chris Trebilcock on behalf of defendant Oakland County Board of Canvassers. I'd like to also note that my client contact Clerk Brown is watching the proceedings on YouTube. She intended to be here, but was delayed and unable to get here. But as it turns out, she may have been able to make it. So I say that in jest, obviously. Procedurally, just to note that the Oakland County Board of Commissioners appealed the trial court's decision on reconsideration only, which was only applicable to the fees. It was plaintiff appellee who appealed the entirety of the decision below. However, on appeal, the appellee failed to raise any issue in the questions of fact or statement of questions presented regarding the fees and focused only on the audit. And therefore, we would argue that that argument has been abandoned or waived by the plaintiff appellee. Second, as it pertains to time, I don't anticipate that there will be a time issue, but I just wanted it to note that we were both from Oakland County Board of Commissioners, that we are an appellee as well as an appellant. So I don't know if that matters to things. On appeal, there's just big picture here. There's two buckets that are issues at appeal. Issue number one, was the proper fee charged per precinct for the recount on Proposal B in Royal Oak in December of 23? And then the second bucket is there a clear legal duty and a clear legal right to an audit in the way that plaintiff appellees demand that or think it should be done? Those are the two buckets. Before I get into some of the reasons why this court should affirm the trial court's decision on the issues of the audit and affirm in part and reverse in part the decision on the motion for reconsideration, before I get into that, I want to just correct, so we're all on the same page here, on a couple of misstatements of law and fact by plaintiff appellee. First, plaintiff said that there is no statute that says that absentee voting boards are separate precincts under Michigan law. That's just incorrect. As the trial court recognized, MCL 168.569A subparen 2 expressly states, quote, an absent voter counting board is a separate precinct for purposes of this act. Okay, so it's been that way since at least 2012. It's been in every recount I've ever participated in since I think the first recount I did was back in 2004. Absentee counting boards are handled as separate precincts, both for counting, for tabulating on election day, and for recount purposes. So that's just a misstatement of law or misunderstanding of law.
Say the MCL site again one more time.
168.569A. Second, this issue about there was no legal recount. Plaintiff admits, and in fact, the law specifically permits under MCL 168.871, allows a recount to be conducted by electronic tabulators, which is exactly what happened here. What you've heard is a bunch of misunderstanding, confusion, or misinformation about how a recount occurs. I just did the only recount that occurred in Michigan in 2024 over in Jackson County under the new statute. And what happens is, before you can even run the ballots through a tabulator, they bring over the box, the ballot container box. They bring it over to a tabulator. There's 2 election inspectors there. There's staff from the Board of Canvassers there. There's challengers from either party that can be there. There's observers that are there. They watch. They go through a checklist to determine whether or not the precinct is recountable. What that requires is a visual inspection of the ballot container to make sure the seals match with the poll numbers and the tape from election night, that it matches the statement of counts that the local clerks have given to the county Board of Canvassers. They go through all that. If they can be recounted, they open the precinct and they look at the poll book and make sure that all the ballot numbers and the ballots issued and the ballots counted all match the tape and the statement of votes. And if they don't, is there an explanation in the poll book as to why it may be out of what we call out of balance, right? They go through all those things. And only when you determine that the ballot or the precinct is recountable, do you run it through a machine or do you do a hand count? There's the affidavit attached in the brief below from Gloria Spann, who's chair of the Oakland County Board of Canvassers, and she testified that they, with other members of the Board of Canvassers, inspected the condition of the ballot boxes, the seals on the ballot boxes, compared the numbers to the seals, numbers listed in the poll books to verify the integrity of the election materials. There is a record of a number of ballots issued in every municipality in this state. And there is a corollary number of votes cast, and they reconcile those when they do a recount and when they do the canvass. That is what the duty of Board of Canvassers is at the county level, and that is what the duty of the Board of Canvassers is at the state level. What you're hearing today is really a rehash of things in 20 20, and just based on information. Again, misinformation. I'd show about the misleading attempt here by plaintiff appellees by just citing Exhibit 3 that they talked about, this EAC Elections Assistance Commission report. First of all, the very text of it says it's an isolated incident that occurred in one county in 2021 in October. Nothing about Michigan, nothing about the 2023 November election in Royal Oak. And not only that, they have the audacity to say that somehow this puts a clear legal duty on Oakland County Board of Commissioners to do something different and not exercise their discretion by talking about the EAT testing it's an isolated coding issue is being implemented by and being identified as being implemented by the manufacturer Dominion Voting Systems. Dominion. Plaintiffs attach an affidavit to their brief on appeal with you guys, noting that the vendor in Oakland County is Hart Voting System. It's not even the same voting equipment.
Also, the last paragraph of that report says that the problem was fixed, right?
Yeah, the problem was fixed. This is the election system here, and after all the issues in 2020 that were raised in the public, court clerks clerks across the state have increased visibility by holding public hearings where they test our local equipment and update the codes so that any problems are identified as early as possible. Those are public meetings and noticed by the clerk of Oakland County. If the plaintiff in this case had a problem with the voting tabulators being used in Oakland County or Royal Oak specifically, those issues could have been raised at any point prior to November 23. They were not, and so they cannot be brought here. So again, those are the issues. But getting back, those are just the problems in the misleading statements I find in the argument. I want to go back to just why this court should affirm the lower court's decision on the audit. It's very straightforward. We cited Barrow in our case. I think you can look at even more recent decisions of the Supreme Court. Holiday versus Board of Canvassers. There was a Court of Appeal decision, but the Supreme Court denied review. That was just in 2024, in September of 2024, involving Cornell West nominating petitions. And there, plaintiffs were arguing that the Board of State Canvassers had certain duties to investigate the fraudulent signatures that were submitted. And the court again affirmed that under Michigan statute, there's a clear legal duty to commence an investigation, therefore can be compelled by mandamus, whatever you prefer, but only the discretion in how to carry that out is left to the Board of Canvassers. And that was the rule in Barrow, which existed before this case was filed. It was followed again in Johnson v. Board of Canvassers, 341, Mishap 671, 2022 case I was involved in involving Perry Johnson and his fraudulent signatures in the governor's race. This is well-established law that while if a board of canvassers refuses to act or conduct a recount or start it, then you can go to court and say, hey, you've got to start this investigation. But the discretion in how to do that, the statute has left that clearly to the discretion and has been time again and again and again reaffirmed, and it's frivolous and vexatious to bring us into court here today. As it relates to the audit or the fees, I wasn't involved in the initial briefing, but when I read it, I understood that there was a little bit of confusion about, well, somehow the court missed the citation about in Michigan law that is just clear black letter law, absentee voter boards are separate precincts for all purposes under the law and the statute. As a result of Proposal 2 and the constitutional amendment passed by voters in 2022, we now have early voting sites, which under the Constitution are to be treated the same as other precincts in the state. Now, we argue that that provision is self-executing and doesn't need additional implementing statute to be able to apply current and existing Michigan law at the time in 2023 to that. What happened in this case is the Secretary of State in coordination with the county clerk, with coordination with the local clerk, all through contracts and service agreements approved by local city councils, approved by Board of Election Commissioners, did a pilot program of early voting sites in 2023. Now, what you have to get back to is what's the purpose of these costs and fees? There's a two-part purpose to it, and you can read it and we cite it in our brief, but there's two-part purpose to it. One is everybody who ever ran for anything and was unhappy with their election were filing for recounts, and it was costing our local clerks a lot of money. And so as a deterrent to filing frivolous or unwarranted recounts, the Michigan legislature said, we're going to impose a fee per precinct on recounts. So every time a clerk has to go and haul out a precinct ballots, hire workers to sit at the tables and do the inspections and count ballots, we're going to charge a fee so that people requesting a recount have a little bit of skin in the game. With early voting sites, and the Constitution requires them to be treated the same as election day precincts or AV board precincts, is the same. The clerk, when they're doing a recount, and I saw this in October of 24, or in December of 24 in Jackson, down in Jackson County, or Calhoun County, I'm sorry, in Calhoun County, you have to take these early voting sites and you have to separate. They're the most labor and time intensive precincts to count in a recount. And so that's why a fee is charged for those. It's required under the Constitution. That interpretation is backed up by the statute that was passed, Senate Bill 603 by the Senate last summer, and becomes effective April 2nd. That interpretation and understanding is backed up by that implementing regulation. Therefore, we would request that the Court of Appeals reverse in part the trial court on the motion for reconsideration and reinstate the $2,000 fee for the early voting sites in the recount in December of 23. With that, I don't know if I have time left over. Hopefully I left my good friend and colleague, Ms. Richards, sufficient time as well. Thank you, unless you have questions.
Thank you.
How much more time do we have?
Probably 10 minutes. Yeah.
Thank you. So Wendell and Richards, I'm here on behalf of the City Clerk of Royal Oak, Melanie Hallis, in her official capacity. So we have heard from plaintiff everything that is backed up, everything that we said in our brief on appeal. There has been no claim that's really lodged against my client that has any sufficiency here. Everything that the plaintiff has raised relates to Oakland County Board of Canvassers and not to the city clerk. Nothing that they're claiming is in her power or authority. All of this is addressed below. What is interesting, though, is that so legally the plaintiff does not deny this. There's nothing on appeal that indicates that they say otherwise. So while the trial court had decided in our favor and dismissed all claims against our client in a separate order from the Oakland County Board of Commissioners, it's only the appeal relates only to the Oakland County Board of Commissioners opinion and order that was issued the same day. And this is apparent when you look at the question on appeal, which relates specifically to granting the board's motion for summary disposition on the grounds. And the primary issue that the audit, incorrect word, was properly conducted pursuant to the Constitution and statutes, where the recount was a mere reiteration of running ballots through the unreliable machines and no investigation took place. There has been no disagreement here that the city clerk has absolutely no authority to run an investigation. The county clerk has no authority to determine what kind of machines or tabulators to use. That's determined at a different level. There's no disagreement whatsoever as to whether there's any relationship between the clerk and the fees, even though this isn't a part of the question. Those are all done at the county level. So it is clear under our Michigan case law that this is dispositive right here. We are done. Verrett versus Westinghouse, in Ray, Indiana, Mettler Walloon versus Melrose, all stand for the proposition that an issue not contained in the statement of the question presented is deemed abandoned. So we are deeming this abandoned, in our opinion. Likewise, even if the plaintiff had preserved some kind of claim, complete failure to develop both in their briefing and clearly in oral argument any claim against the city clerk necessitates the fact that this was the right decision by the trial court. We should be out of this case. And it's quite frankly vexatious to include us at this point. But even if this court were inclined to review the merits of plaintiff's claim, the circuit court correctly concluded that plaintiff was not entitled to relief. As we stated, Michigan election law assigns the role of conducting recounts and investigations to the county board and not the city clerk. This is clear under statutory law. MCL 168-869 states that upon the filing of a petition of recount, the giving of notice is given to the Board of County Canvassers, which shall be summoned by the clerk of the board and make an investigation. And 872, which is a big part of this debate, also relates to the investigatory powers of the Board of the County Canvassers, not the city clerk. The city clerk is not involved. I will also note that they talk about mootness here. And there has been a change. So they talk about mootness and claims that there's this issue of potentially, a chance of repetition and evading review, and therefore we should be looking at this even some more. That is not the case with this statute. An aside, 872 has been amended and it goes into effect in April 2025 before the next election. And that actually takes the investigatory powers from the Board of Canvassers and actually puts it to the prosecuting attorneys or attorney general. So the new amended statute states that if a Board of Canvassers conducting a recount has good reason to believe any fraud or violation of law has been committed in the canvass or return of votes, then that Board of Canvassers shall be, subject to Section 2, refer any matter the Board of Canvassers believes warrants investigation to the following. And it goes on to state that it should go to the prosecuting attorney or attorney general, depending on the situation. So even and still, if they're claiming that there's some sort of issue that could be repetitive, they're asking you to be making a decision on a statute that has no applicability in the next election. Just to put that out there. But okay, so the circuit court correctly concluded that the plaintiff's complaint made clear that he sought an investigation at the Oakland County Board of Canvassers and not the city clerk, and failed to identify any recount-related duty on the part of the clerk. You can look at the complaint itself and all the exhibits. It is very clear that they're
And the brief on appeal, there's
And the brief
nothing
on appeal.
alleged.
Yes.
Yeah,
Exactly.
there's no duty alleged for your client.
Exactly. So this has not been disputed. And really, this is, again, dispositive right here. Again, city clerk has no authority or a role in collecting the fees. And this is again indicated in the complaint itself when they submit a receipt that was sent to the Oakland County Board of Canvassers, or to Oakland County and not to my client. So once again, unrelated. As the circuit court concluded, the plaintiff did not seek any relief against the city clerk, respect to recount fees either. And they do not allege they paid any fees to us. Finally, although plaintiff does not challenge a circuit court's dismissal of his claim relating to record preservation, any such challenge would fail on the merits, as the trial court rightly decided. They abandoned that actually at the trial court level as well, that we raised this in our brief and it was not addressed, but also it was all conjecture at the time. Not only is it moot because this is well past that election, it was in 2023, but nonetheless, it was the only support in the complaint were statements relating to like future events. So there was really nothing there that had any, for past events. So it was relating to memos from the Secretary of State about past elections and preservation of records in that context, as well as a memo, a directive indicating that clerks should not be distributing election materials to outside people, completely unrelated to this issue. The one thing I will say too, and we addressed this in our earlier brief, some of this was the C8 motion. We were on the pleadings only, and so we're not going to address all the affidavits, but the point kind of relating to the one affidavit that was included as part of the petition for recount really relates to a voter who had placed their absentee ballot in a mailbox. And as we all know, the U.S. Postal Service is very busy, depending on, particularly near an election, depending on how close you're to election, there is no guarantee that that ballot is going to make it to the city clerk's office on time. And we do not have a post office rule in the state unless you're an overseas or uniform voter. So the fact that a ballot may not make it to the city clerk's office is not fraud. And in actuality, there's transparency built into the process as part of Prop 2 enacted in 2022 that allows you to track your ballot. And when this case was filed, there was a tracker on Secretary of State's website, and you could track the status of your ballot. If your ballot had made it to the clerk's office, you would know from that tracker. You could also call the clerk's office and find out. So there's transparency built into this process already, that continues to this day. And I think it's really important for taxpayers and voters to understand that this exists, and maybe some of this confusion could be avoided and help to not divert so many public resources to trying to explain what is really just the electoral process that we have right now. So with that, I would welcome any questions, but we do, for all these reasons, ask the court to affirm the circuit court's February 12th, 24 decision granting summary disposition for the city clerk.
Thank you.
Thank you very
you.
much. You have some time for rebuttal. I'm not sure on that. Probably a handful of minutes.
Thank you.
Yeah.
There are a number of matters that I want to respond to.
Can you start with the assertion that you didn't put the second issue in your questions presented?
Your Honor, I believe that it was discussed in the brief and in detail, the fee, and it is included in one question presented. It covers, so the question is phrased is, did the trial court err in granting the board's motion for summary disposition on mootness grounds that the primary issue was that an audit was properly conducted pursuant where the recount was a mere reiteration of running ballots through the machine. Mr. Harrison is contesting, as we have stated, that a recount did not occur, nor did an investigation. The court could remand it back and give him a full refund. He's contesting that it even took place in the first place. And, Mr. Harrison did not mislead the court with regards to his attachment with the Dominion root cause analysis of the EAC report. That is attached to demonstrate, and it was clear throughout this case that this jurisdiction used, and as I stated, Michigan uses 3 different vendors, ES&S, Hart, and Dominion. It was attached to show that it's not misinformation, that erroneous source code, when we have no transparency with machines, can cause an inaccurate tally. And we rely upon vendors in reporting results. And that's why the significance of a recount and investigation is so important. And it does not say that it's confirmed that this issue has been resolved throughout the country. In fact, the 5.5B system, and I don't want to go too far into Dominion, the patch was not utilized in a number of jurisdictions that then reported problems. So we rely again upon the vendor fixing something, and only that would be caught if a proper recount and investigation is done. And that would be one with transparency that reconciles every aspect of the election, where under 4165, the clerks maintain all records. And that would be the qualified voter roll. The voter roll is maintained in multiple places in Michigan. It's at the local level, it's through the driver database, it's stored on some of the tabulators where they could be remoted into. Experts have found the voter roll is in multiple places. So unless all of the data is reconciled and a full investigation takes place, these issues would not be caught, and that's why this matter is not moot. While the law has changed where the prosecutor and the police are recommended to be referred to with the Board of Canvassers in a recount if there's a problem, that could have still happened here. The Board of Canvassers could have and should have, based upon the affidavits that people were asserting that they voted and their vote was not counted, and they're not even reflected as having voted. That could have been referred, and the police could have assisted the Board of Canvassers in an investigation. But again, none of that happened. It was a non-transparent process where the same stack of papers were just shoved through the same machines. With regards to attachment F, again, they referred to misinformation, and there was a comment about 2020. In 2020, the Whitmer v. King case was filed in federal court, where it was promptly dismissed and called frivolous. There was a FOIA request in 2023 of all of the Detroit paper data that would have been discovered had discovery taken place in that case. in attachment F, it shows that there were up to 35,000 potentially fraudulent ballots where the city of Detroit workers that were looking at the paper were saying the paper doesn't match. And there were more ballots than envelopes and more envelopes than ballots. So my point with this, and this attachment reflects, is that only a thorough investigation of the paper timely will reveal such issues. And that report is a really significant report because it was the expert that conducted that FOIA analysis is an expert that's been on retainer by the Secretary of State in the city of Detroit for 20 years. The FOIA utilized their own expert. But with that said, this was a non-transparent process. So Mr. Harrison is not saying that he gets to dictate how the investigation takes place. He's saying that the recount with the machine is an unconstitutional recount that's not transparent and then diverts all control to the vendor to again electronically report results. And some type of investigation needs to take place, and it should have taken place here, and it did not. So for those reasons, he asked that.
Well, just for clarity, an investigation did take place, but it wasn't to the satisfaction of your client.
My client.
It's already been described that, and your client saw that an investigation took place with respect to individual ballots, the seals. There were steps taken to do an investigation by hand with eyes before even the machine-based recount.
I'm glad the court is asking about this. My client, first of all, they did not count 2 bags. They were not able to do a complete recount. That did not take place because if it's not properly sealed, it can't be recounted. So 2 bags were not counted. Secondly, none of that's sort of a show that goes through the motions. That's not an actual investigation that would verify any.
But then this gets to the point you just made. You said your client's not allowed to dictate what the investigation would look like, but there was an investigation, but now you're saying it was just for show. It wasn't good enough, but we're bound by Barrow, which says, okay, yes, you have to be responsive. You have a clear legal duty to investigate, but it's not for the person who wants the investigation to dictate what it should look like.
My client disputes that an investigation was taken place. He agrees that there were steps taken to put the ballots through the machine again. So the bags were unsealed and a seal number was looked at. None of that reconciles the affidavits that were provided that reflect that people said they voted and it's not showing that they had voted. So what was in the bag is what needs to be investigated. That process would not determine that. So what he's saying is that the police could investigate the list of people that voted, how it's possible that people that under oath said that they voted and they're not on the list, right? What's in the bag? Just taking out the bag, just like if you're at the bank and putting it through the machine counter twice doesn't check it. It's actually verifying it by hand, looking at the paper in some respect. So while he's saying he doesn't need to dictate that entire process, there was no request for a police investigation. There was no further expert brought in on to look at the paper to make sure that these were all valid votes, and then to figure out where the missing votes were of why it was reflected and how that could possibly happen, that people were reflected as not having voted, where they said under oath that that's what it said and they did vote. So that's what he's asking the court to consider, that this non-transparent process of a machine count is unconstitutional and reverse it back to the lower court. Thank you.
And Mr. Treblecock, I think you have a few minutes for rebuttal on the fees issue only, given that you're appellant in that case. You don't have to.
I'll just say, I guess a question for the court. On the fees issue, as we cast it, I think we've stated our piece on that. On the fees question, as I just heard it articulated by plaintiff appellee, I would have just a couple of quick rebuttals. If you indulge me for a minute. One is everything that I just heard screams discretion, 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 which this was a complaint for declaratory judgment and a complaint for mandamus. And where there's discretion, mandamus will not lie. I believe that's a pretty darn close to a quote from countless Court of Appeals and Supreme Court decisions. So again, They may not like the process, but that is the statutory process we have in place and has been affirmed time and time and time again by this court. Second, I didn't see a count or a claim considered before raised here or raised in the complaint that somehow doing a facial challenge to the Michigan election law is unconstitutional. So that's the first I'm hearing that somehow there's a facial challenge to the constitutionality of the Michigan election law, because plaintiffs admit that a recount, that they took ballots out, they inspected them, and they reran them through the tabulators. They admit that Michigan election law allows that. They admit all these things. They just don't like it. They don't like the process. They want to see every single step.
And they said that their dissatisfaction with the process as it relates to the fees requires a full refund. Do you think that that by raising it in that way, that they've satisfactorily preserved the issue with respect to fees?
No, I don't believe so, because the law says here's what a recount contains. They admit that that recount took place. Their dispute, and they didn't brief this at all. And to the extent they did, they were wrong, but I don't believe they briefed it at all or raised it, is that they didn't challenge the court's decision. If you read their appeal brief, they're challenging the court's original decision. That we then filed a motion for reconsider and the judge corrected it. If you say there were 3 buckets of fees on the original decision, the court went and granted Oakland County's fees for 2 of those buckets. They disagree with all of them, but they're only addressing the original decision, not the decision on motion for reconsideration. They don't address why the court got it wrong on the absentee ballot counting boards, when there is specifically statute saying that absentee voter counting boards are precincts for all purposes under this act. That's not addressed at all. So I do believe that that fee argument is waived procedurally. And I'll just note, their brief was 70 days late, then it got corrected 2 days later. The nature of this appeal and the clear statutory requirements that are just being ignored or glossed over, I think, is concerning, and what leads to more and more of this litigation. And so, again, we reiterate at our client's request that this does constitute a vexatious appeal, whether it's if you look at the fee issue, whether you look at the audit issue, and certainly, as you heard from my colleague, Ms. Richards, as it applies to the clerk. So thank you.
Thank you. This case will be submitted.